as possible. Then you get the benefits of the international law degree. So this mistake I did it, I never learned foreign language other than English. That's why I couldn't end up in any international organization. That mistake you should not do. That's why my request is learn as many languages as possible. There are institutions offering foreign languages. Learn French, Spanish, Chinese. Nowadays Chinese is also very preferred language. All these languages are very important. You can go around all places with your degree. You can get good employment in any of the countries. That's the possibility. That's the possibility I'm speaking about. I'm not speaking about an impossible thing. I'm speaking about a possibility, legally, practicability. So they get the international LLM degree in international law. With this, acquire proficiency in one or two languages, foreign languages, and see your potential. You will surprise you. It will be a surprise for you. Your home case will be a surprise for you. So therefore, this particular convention is concluded in 5-6 languages. All these languages are very prominent languages and official languages of the United Nations. Arabic language, Chinese language, English language, French language, Russian and Spanish language. So these are 10 ratifications. So 10 ratifications आने के लिए so 8 years time लगा. So signature process is concluded in the year 1980. The last ratification, 10th ratification is received in 1988, and therefore this is the time gap, this much time gap between signature and ratification. So this particular convention is concluded at Vienna, the capital of Austria. That's why it's also known as Vienna Convention on contract of sale of international on contract for the international sale of goods. It's also called, listen carefully, it's also called Vienna Convention for contracts on international sale of goods because it is concluded, it's signed at Vienna, capital of Austria. So this particular convention of signature, it's deposited with the Secretary General of United Nations. Why it is deposited? He is the depository. Secretary General of United Nations is the depository. Every multilateral convention concluded under the auspices of United Nations shall be deposited compulsorily with the Secretary General of United Nations. Therefore, it is deposited with him and he is the depository, recognized depository. Now, this is why this convention, why at all this convention, what is the reason? What could be the reason behind the conclusion of this convention? Convention is for this condition, for these reasons. So, all countries wanted to have a convention, modern convention. It's a convention based on fair principles. It's a convention based on regulating international sale of goods. That's the desire of all states. Because all states are wanting to have a fair convention, modern convention governing the international sale of goods, they have signed this contract. And this contract is signed and automatically, there are 65 countries or 95 countries, all these countries are member countries and this binding on all countries. So what is the purpose? Another purpose of this is equality. All countries wanted uniformity, equality as far as the sale of sale transactions, international sale transactions is concerned. So this particular convention is not there. This particular convention is a uniform convention. A uniform convention. It applies to all member countries. Suppose this is not there, this is not signed. What will happen? What will happen if it is not signed? Respond to me. Respond to me. What will happen? Suppose this convention is not there. I am saying this is a multilateral convention. This is a convention governing the contractual relation of all countries uniformly across all countries. Suppose this is not there, this convention is not there. What will happen to all countries? It leads to confusing situation. Seller says Mera law is superior. Mera law applies to the sale transaction. Buyer says Mera law is superior. This contract will be governed, contract of sale will be governed by the buyer's convention. ऐसा झगड़ा हो जाएगा. So parties will quarrel. That dispute will continues forever without any solution. So that situation cannot be warranted. It's not necessary. So all the countries wanted to have a peaceful solution to a problem, to a trade dispute. That's why this particular convention is concluded by all states under the auspices of United Nations for the purpose of resolving the trade disputes peacefully, without any complications, without leading to uncertainty. This is the purpose of this multilateral convention. This multilateral convention is excellently drafted, taking into consideration the interests of both the seller as well as the buyer. It's not arranged in a narrow language. It's arranged in the broadest language possible, so, taking into consideration the seller's interest as well as buyer's interest. So that is the beauty of this convention. That's why most of the countries became parties to it. 95 countries is not a small number. Across the country, across the world, 200 countries are there. 95 countries are parties to this convention. They agreed that they will be bound by the provisions of this convention. But unfortunately, India is not a party even today also to this convention. We do not know the reasons of India not becoming a party to this convention, but it's a fact India has not signed this convention. And another important country is United Kingdom also not signed this convention. So both these countries not signed. America has signed, France has signed, Germany has signed, China has signed. All big countries have signed this convention. They became parties to this convention, and unfortunately India is not a party to this convention. So let us say something about it. So the purpose is to bring equality and mutual benefit, for the mutual benefit of the seller and the buyer. This particular convention is necessary, and therefore all countries sign this contract, sign this agreement, sign this treaty, multilateral convention, and this particular multilateral convention will have a binding effect on all the 95 countries. All the 95 countries. Now, as a matter of general principle, what's the contract? Who signs the contract? What is the contract? Tell me. What's a contract? What's a contract? You must have learnt it already in the first year itself. So I expect some minimum knowledge from you. So what's a contract? It's an agreement enforceable by law. So when an agreement becomes enforceable by law? No. When an agreement becomes enforceable under law? When it is signed by parties competent to contract. When it is signed with a lawful objective. When the agreement is signed with a lawful purpose. When the agreement is signed for a lawful consideration. So when the agreement is signed by two persons with competence, So without competence, parties cannot sign a contract. Who is not competent to the contract? Who is not signed? Who is not competent? Minor is not competent. I saw. So therefore here also, international, then the agreement becomes a contract. Once the agreement is validly signed by persons of competent, with competent persons for lawful object, lawful consideration, the agreement becomes a contract. It becomes a contract. The same thing here also happens in international contract also. Whatever elements are there for the conclusion of a contract, all those elements are to be present in the international sale of goods also. No, nothing peculiar, nothing special, except all the elements just you have learnt in the Contract Act, General Principles of Contract Act. So now this particular contract applies, as far as application is concerned, international sale of goods applies to these places. Explain it to me one by one. What is it? In the first place, the convention applies In the first place, the convention applies to parties whose place of business is different countries. I said to you in the beginning, seller sits in one country, buyer sits in another country. Their place of business must be separate. So seller's business in his country and place of business is in seller's country and buyer's place of business is in buyer's country. Then only this convention applies to that particular situation. Secondly, when the rule of private international law leads to the application of a contracting state, what does it mean? What does it mean? Then also this convention applies to that particular situation. What does it mean? Second one. What does it mean? When the private international law, rules of private international law lead to the application of law of contracting state. What is private international law? When does it lead to the application of contracting state? Private international law means national law of a country. Suppose just now I told you conflicting situation. If this convention is not there, so contract is signed between the seller and the buyer, then dispute aa gaya. After dispute, the seller says mera law apply karega, mera law applies, and buyer says mera law applies. Then it leads to conflict. Instead of leading to a conflicting situation, this convention is safe. So this is a convention uniformly applicable to all countries for all transactions. Therefore, in that particular conflicting situation, instead of heading to the conflicting situation, we can take advantage of this convention. Parties can say that this will apply to their transaction instead of heading to the conflicting situation. The third one is when the parties make a specific choice of contracting, specific choice that this convention applies, then also this convention applies. If both the seller and the buyer specifically agrees that this convention applies to the transaction in case of dispute, automatically their mutual agreements binds the parties. Whatever mutual agreement is there about the resolution of the disputes, that automatically applies to them. The convention governs their relation because both of them mutually agreeing they wanted to have this convention to be applied to a dispute arising out of the contract of sale. Because of mutual agreement, mutual consent binds both the parties. Both of them saying in case dispute arises out of the sale transaction, this particular convention will apply and the dispute will be resolved by this convention only. I saw mutual agreement is there. Because of their mutual agreement, this particular convention also applies. In only three situations, this convention applies, otherwise this convention will not apply to any other situation. The first one for the application is the buyer must have a place of business in his country. The seller must have place of business in a different country. Then only this convention applies. The second one is in case of the rules of private international law lead to the application of contracting state, then also it will apply in case it leads to a conflicting situation. So 200 countries are there, 200 transactions are there. Buyer says buyer's law will apply, seller says, so that's a conflicting situation. It's a confusing situation. Instead of heading to the confusing situation, they can safely apply this convention to their problem, to their dispute. Second one. And third one is by mutually agreeing that this law will govern their dispute, it can apply their things. This convention will govern their relations. So only these three situations the convention applies to internationally. Sometimes I told you the place of business. The first condition is for the application of this convention is the seller must have place of business in his own country. The buyer also must have place of business in his country. Sometimes they may not have any place of business. Buyer may not have any place of business. Similarly, seller may not have any business. Even if they have place of business, sometimes they don't want to reveal their place of business. they want to keep it secret, private. They don't want to mention it in the contract. When they don't want to mention it in the contract, then contract will not become invalid. Contract remains invalid even if they don't mention about the place of business. That's what it says. So the parties have their place of business in different states is to be disregarded. So that's not a mandatory principle. If it is there, if it is there. If the seller have a place of business in his country, that's good. Similarly, buyer have a place of business, it's good. If they don't want to reveal the place of business, that's also fine. That's also fine. So simply because place of business is not mentioned specifically, simply because parties never, they have not revealed the place of business, that doesn't mean that contract is bad in law. Contract still continues to be valid because it's an understanding. It's an understanding between the seller and the buyer. They have to enter into a contract of sale between them. That understanding is sufficient for them to take the dispute to a proper forum or proper court of law. That's sufficient. Similarly, at the time of the conclusion of the contract, the nationality of the parties is irrelevant. So whether the contract of sale, international contract of sale, may be concluded between any nationality, between two persons of any nationality. Whether the seller is Indian or Chinese, whether he is a Japanese fellow, it's immaterial. The buyer's nationality is immaterial. Only material thing is that they have to sign the contract under this convention. If they sign the contract under this convention, that stands valid. So nationality of the seller, nationality of the buyer has no relevance in international sale of goods, international sale of goods. Similarly, the status of the person, the status of the seller is also not relevant. Whether he is the governor, whether he is the principal of a college, whether he is the director of a college, whether he is the assistant general manager of a bank, his status is immaterial. Whether seller has signed the contract or not, whether seller has agreed to sell the goods or not, whether buyer has agreed to purchase the goods or not, itna hi relevant hai. Not more than that. Not more than that. So whether you belong to a particular class, whether you belong to a particular nationality, whether you are a citizen of a particular country, all those things are immaterial, irrelevant for the purpose of signing the contract. So one more important thing is, this is a general principle. Once you sign the contract, it applies both domestic contracts as well as international contracts. Once you sign a contract validly, once you reach a contract validly, what do you mean by signing of a contract validly? Once you sign a contract validly, the signing of the contract automatically creates a certain responsibility to one party and responsibility to other party. In other sense, in legal sense, once it is validly signed, contract is validly signed, the contract which is validly signed will create certain rights to one party and obligations, and similarly it creates certain rights and obligations to other party. This is the result of signing a contract validly. Valid signing, valid conclusion. The same thing happens in international sale also. Once it is signed, it produces certain rights to the seller, it produces certain rights to the buyer, it produces certain responsibilities to the seller, it produces certain responsibilities to the buyer. So this is what happens. Now let us see what are the responsibilities of the seller in an international sale of goods. Similarly, what are the responsibility a buyer acquires by signing an international? Only two responsibilities, not more than that. Let us see the responsibilities of. Okay.
tea, coffee.
Okay.
This will.
Okay, no problem. You can announce it.
Let us take a break, 15 minutes.
Okay. We can have a break of 10 minutes or 15 minutes. After having some tea, we gather together again. Okay? Have a break, 15 minutes break. I will sit here.
We'll go down. Chairman sir is there.
Okay.
Right one.
Yeah. Contract breaches. Contract breaches. Breach means crack, crack, break. So contract gets cracked. Break. Once the contract is cracked, break, what happens? What is the result of it? One party gains it. The party, one party. Okay, come on, quickly. Because of the breach of contract, the one party suffers damage. One party will be intact, his position will be intact in the contract. But the other party, other party suffers some damage. Thus, damage damage is to be compensated by money. Most of the times, money only, in terms of money, because he is suffering loss. So both parties are there. One party is willing to perform his obligation. The other party is not ready to perform his obligation. He wants to go back from his promise. When the other party goes back from his promise, naturally contract breaks or breached. When the contract is breached, naturally the person suffers some damage. The person who commits the breach, he is right, all right, his position will be all right. But the person, because of the breach, he suffers some damage. That damage cannot be left as it is. It is to be compensated. Most of the time, it will be compensated by way of money, by grant of money, by the award of damages. Here also, in a contract of international sale, the sale contract, when it is validly concluded, it creates certain rights to the seller, international seller, and also it creates certain rights to the international buyer. It creates certain obligation to the international seller, and it creates certain obligation to the international buyer. So let us see what are the obligations of the international seller. Very limited obligations. Only two obligations are there. These are the obligations described in chapter 3 of the part 3 and chapter 3 of the Convention on International Sale of Goods. This is a multilateral convention. This is the contract law governing the contractual relation at international level. Just like we have contract of sale of goods at domestic level, there is a law. That law is called multilateral convention on international sale of goods. So both the parties are governed by this convention, by the principles of this convention. So this convention is not an ordinary convention. It's a multilateral convention concluded in the year 1980 under the auspices of United Nations. United Nations organization is a multilateral organization. It's a multilateral body established in the year 1948 to secure peace, world peace and security. So therefore, this is a multilateral organization established after the Second World War. This multilateral organization is governing all the relations between all countries. Political relations, especially political relations, economic relations, contractual relations like this. So therefore, let us see what are the obligations this particular convention speaks about. When the contract is validly concluded between the seller and the buyer, seller has two obligations, very limited number of obligations, only two obligations. The first obligation is like this. So because adjustment problem, after seeing this much of crowd, I am confessing, we have in Gujarat Maritime University, in LLM, only 10 students. Only 10 students. Here, so much crowd. So much crowd, maybe because of inconvenience and other things, little noisy. Naturally, it happens like that. Now we are okay on the track. Please follow me and interact with me. I will, whatever doubts you have in your mind, I can solve those problems without any hesitation. I don't restrict your freedom. You can ask any question, even in the middle of the lecture. So you are free to talk to me, interact with me, and also interact with interact with me, freely. Whatever idea you have, you can share with me, whether it's a bad idea, good idea, it doesn't matter. Communication of the idea is more important. Interaction is more important. Through interaction, we can learn more things, many things. So let us see the obligations of the seller in a contract of sale of house. Only two obligations are there. The first obligation is when the contract is validly concluded, the basic duty of the seller is he has to deliver the goods to the buyer. He has delivery of the goods to the buyer. Physical delivery of the goods to the buyer. Buyer sitting in the place of his country, in his place of the business in his country. So he is sitting in another country, seller is sitting in one country, buyer is sitting in the other country, separated by long distances. Long distances. So therefore the seller promises he will see that the goods are physically delivered to him. Delivery of the goods, it is the responsibility of the seller. Physical delivery of the goods from the seller's place to buyer's place. Not only physical delivery of the goods, the seller also promises, seller has to see that all the documents relating to the goods are delivered to the buyer. Why all the documents are to be delivered to the buyer? So on the delivery of the documents only, the seller gets good title to the goods. Seller gets good title to the goods. Without documents, the buyer will not be able to prove his title to the goods. That's why the seller is expected to deliver all the related documents to the buyer on the physical delivery of the goods. So therefore, what the first duty is, the seller has to deliver the goods, not only delivering the goods, but also handing over of all the documents relating to the goods. So without the documents, buyer will be in soup. He will not be able to prove his title to the goods. People may say that you have stolen these goods. So he must have sufficient evidence in his hand that I have purchased the goods from the seller. So this happens when he has got in his possession all the relevant documents. All the relevant documents. What are the relevant documents in an international sale of goods? What are the relevant documents? Demand invoice. What are the other things? Bill of lading. If the goods are shipped by sea, bill of lading is an important document. It's a proof to the title to the buyer to the goods, and also second one is demand invoice, bill of entry. Second document is what? These are the three important documents. Important documents for the importer. Similarly, export document will be there. Separate set of documents. For export के लिए export documents, for import के लिए import documents. So export के लिए what are the documents to be filed by the exporter, by the seller? In this case, he has to create demand invoice. He has to prepare what the bill of lading is to be prepared. If not bill of lading, if the goods are sent by air, anyway bill. If the goods are sent by lorry bill. If the goods are sent by train receipt. All these things are relevant document is to be prepared. Apart from bill of demand invoice. Apart from demand invoice and bill of lading, there is third document. That third document is called export bill. Export bill also to be sent to him. So these are the three mandatory documents to be produced by the seller when he sells the goods or handed over to the buyer. So buyer in his country, he has to prepare certain documents. They are also mandatory. Without these documents, he cannot take physical delivery of the goods in his country. If he is not able to take delivery of the goods physically, then he cannot take the goods to his place of business. If he is not able to take the goods to his place of business, he cannot sell the goods to the retail customers like you and me, and ultimately he suffers loss, he incurs loss. As a mandatory procedure, the buyer also in the importing country has to submit certain document. The first document is common document, bill of lading. If the goods are sent by sea. Second one is if the goods are sent by air, then bill. If the goods are sent by train receipt. If the goods are sent by road, lorry receipt or truck receipt. If the goods are sent by any other mode, receipt, or constant receipt. The second document is also again invoice, demand invoice, and the third document in this case is bill of entry. Instead of shipping bill, exporter has to file the shipping bill when he is exporting the goods. Importer has to file bill of entry in his country. What is bill of entry? What is a bill of entry? What's the bill of entry? What is the bill of lading? What is the bill of entry? What is the shipping bill? All these are different documents. Bill of entry means it's an indication. It's a document. It's an indication giving indication that goods are in transit already loaded onto the ship. Goods are in transit. Goods are on the way. They are going to reach certain port in so and so country on a particular day at a particular time. The goods will certainly on that particular day, particular specified time, goods will reach to that country, importer's country. This is a proof. This is an indication to the customs authorities in the importer's country that so and so ship is bringing so and so goods in the name of so and so. This is an indication. Then on that particular day, ship will reach to that particular port. Then goods will be unloaded from the port and they will be kept in the customs warehouse. From the customs warehouse, after inspection, the buyer will take the goods, physical delivery. After paying the import duties. Import duty is also called customs duty. Customs duty, import duty, one and the same. Mere payment of import duty is not sufficient. In addition to the import duty, he has to pay other charges also, if at all. Any charges are to be imposed or levied by the customs department. There may be other charges also. Whatever charges the customs authorities require him to pay, he has to pay those things. After paying all the charges, customs duty, then ultimately final document is customs clearance. This customs clearance is called import clearance. Customs clearance is import clearance. Without clearance, you will not be allowed, importer will not be allowed to take physical possession of the goods. Import clearance is an important document. So after taking the import clearance, he will take the goods into his custody, carry the goods by a truck to his place of business. He will keep them in his storehouse. So small lots, one by one, small lots, he will sell to the customers like you and me, consumers like you. So these are the important documents. The first important duty, the first important obligation for a seller in a contract of sale is the delivery of the goods. Apart from the delivery of the goods, he has to deliver the relevant documents. Then only his formality will be complete. Without the delivery of the goods, mere physical delivery will not be sufficient. Why it not be sufficient? Why it not be sufficient? Why documents are to be accompanied? Just now I gave the reason. Without relevant documents, he will not be able to prove his title. He will not be able to purchase it. He will not be able to prove that he has really purchased the goods from the seller. In order to prove that he is the owner of the goods after buying, so he has necessary documents in his possession. That's why documents are very important. All these documents are to be submitted to the buyer, and buyer has to submit it to the customs department in his country. After submitting all the formalities and documents, he will be able to get the physical delivery of the goods in the importing port, importing airport, and then he will take the physical possession of the goods. The second one is conformity of the goods. Conformity of the goods are third party claims. So this is the seller is expected. The seller is expected. The goods must be conformed to the sample shown by him. At the time of negotiation of the sale of goods, negotiations will take place normally between the seller and the buyer before signing the contract. So then at the time of negotiations, the seller will be normally show the sample to him. But this is the sample. This is the quality of the goods I am going to sell you. So he will show the sample and quality, exhibit the quality to the buyer. Buyer naturally believes whatever he shows, seller shows. He believes, he relies on the exhibition, whatever showed to him. Then he comes forward, he mentally prepares himself that he wanted to purchase it, he will be ready to pay the money to him. Therefore, he will pay the money ultimately. When he makes up his mind, he pays the money. When he pays the money, takes the goods into his possession, then the goods take delivery must conform to the quality shown at the time of negotiation. To the quality shown, to the same kind of quality, same kind of description, the goods must conform at the time of negotiation. Then only the contract automatically will be performed. So if any teda aayega to idhar udhar teda aayega to, then he cannot do the things. Again, contract will automatically, the buyer refuses to take delivery of the goods. Once he refuses to take delivery of the goods, automatically contracts gets broken. Contract commit again, default, again legal process. All these things automatically will follow. Apart from this, third party claim also. When the seller delivers the goods, he must deliver the goods free from third party claims. What do you mean by this? What do you mean by this statement? The goods must be free from third party claims. What do you mean by this? Come on. Without nobody, somebody third party must not come forward and claim the goods as if goods belong to him. When we purchase the property in villages also, when we purchase the property, house property, land property, हम purchase करता है in villages. When we purchase the property in villages, mostly in summer, we also expect the same thing from the seller. The property which is purchased in land property, house property in the villages, I expect that property is free from claims, third party claims. No third party should come forward after purchasing that the property belongs to him. He has got an interest in the property. Nobody should come. I expect this kind of minimum expectation. This minimum expectation also should be there in international sale of contract. When the goods are delivered by the seller to the buyer expects this minimum expectation. The buyer expects the goods are free from any claim by the third party. Then only he can enjoy the goods purchased by him. Then only he can take physical. Then only he can sell the goods to other parties freely without any mental block. That's all. If the third party claim is hanging, he cannot sell the goods freely. He cannot make money. Ultimately, he suffers loss. Buyer will suffer the loss. That's why the minimum obligation of the seller when he delivers goods physically then the buyer expects this kind of minimum obligation on the part of the seller. They should be free from third party claims. Then these are the two things. So therefore, sometimes it may happen. The third one is remedies of the seller, remedies of the buyer. I said, remedies for the breach of the contract by the seller. Seller enters into contract. He has agreed to sell the goods. He has signed the contract. Buyer agreed to buy the goods. He has signed the contract. Contract is completed for various reasons not important, reasons not material. The only thing is whether contract is breached or not. This is the relevant thing. So suppose after signing the contract, for various reasons, buyer is not ready to perform his obligation. What does it mean? Buyer is not ready to to deliver the goods. He is not ready to give the documents for various reasons. बाद में price increase हुआ होगा. He gets more price. That's the knowledge. That's why he may not be ready to sell the goods. He may not be ready to give the physical delivery to the buyer. He wants to go back. When he wants to go back, really goes back, automatically contract breaches. So by the breach by the seller, naturally who suffers the damage? The buyer suffers the damage. So physical suffers the damage financially. That financial damage is to be compensated. This is the remedy. These are the remedies. What are the remedies? One of the remedies, just like domestic contract, one of the remedies to be available to the buyer is compensation. Other remedies are also there. We see all the other remedies one by one, very briefly. Are you able to follow me? This is the first thing. Article 30, Convention on International Sale of Goods. What it says, very correct language, very strong language. Normally in legal documents, no correct language, no strong language. But in this convention, the language usually is very tough language, absolute in terms, absolute in terms. Let us see what is the first duty. The seller, what it says, the seller must deliver the goods. Must deliver the goods. ऐसा बोलता है. The section is saying very strong language. Strong language, he must deliver the goods. No escape for the seller. No escape for the seller. Not only delivering the goods, he must hand over all the documents, necessary documents relating to the goods. Apart from necessary goods and necessary documents, then only the property in the goods will be transferred from the seller to the buyer. The title, transfer of property means the title in the goods will be passed from the seller to the buyer. This is the first duty. First duty of the seller under Article 13. It's not section. I wrongly written section 13. It is Article 30 of the International Convention on International Sale of Goods. Apart from that, this is another thing. So place of delivery. Place of delivery. The seller has to deliver the goods at the place agreed upon. At the place agreed upon. Time agreed upon. Whatever time agreed upon, whatever place agreed upon, the seller has to give delivery of the goods at that particular place, at that specific place agreed upon. Apart from place, another important thing is the goods also must be delivered by the seller to the buyer at the specific time. समझ में आया? At the specific time mentioned in the agreement. Mentioned in the agreement. Time is important, place is important, and the seller is bound by the time and place. He cannot deviate from the time and place. If he deviates from the time and place, automatically contract breaches. Contract gets breached. Once the contract gets breached, automatically the buyer gets the right to claim compensation and whatever remedy available to him under this convention. Under any circumstances, buyer should not be allowed to go back his promise, to break his promise. Promise is promise, commitment is commitment. Once you make commitment, commitment binds you. That is the principle under the international law also. Pacta sunt servanda is a principle, hai na? Agreements are to be respected, agreements are to be honored. So parties will not be allowed, even in international treaties also, international relations also, countries will not be allowed once they commit themselves in political relations or economic relations. The same thing, the same principle applies even in sale contracts. Once the parties commit themselves that they will do certain things for the other party, the party who promises must stick himself to the promise made by him, commitment made by him. Under any circumstances, he will not be allowed to go back from his promise. Once he tries to go back from his promise or breaks his promise or goes back his promise, ultimately he has to pay the penalty. He has to pay compensation. All these things, all these consequences will flow out of the breach of the contract. Out of the breach of the contract. Now let us see what are the place. Place is important. Just now I told you. Ayo, what is this? Time is important. Oh, yours is 33. It's something. Okay. Date is important. Date is important. Time is important. Date of delivery is important. Take here the date fixed. If a date is fixed, take here blue letters. If the date seller must deliver the goods. As a language hai. The language is very tough language. Absolute in terms. So what the seller says, what the seller's responsibility is absolute. The seller must deliver the goods. If date is fixed by from the contract on that particular date. If the period of time is fixed, then at any time within that period, unless the circumstances indicate that the buyer is to choose a date. So in any other case, within a reasonable time, the delivery must be given by the seller to the buyer. If a specific date is fixed, delivery must be given on that specific date. If period is fixed, what is the difference date and period? So the seller ऐसा लिखा जाता है contract में. Contract में ऐसा लिखा जाता है. The seller will deliver goods in the next 2 weeks, within 15 days, within 20 days. That is period of time. If date is there, specific date is on the specific date, delivery is to be given. If period is given on the before the expiry of the period, he has to deliver the goods. Sometimes no period, no date will be mentioned. Both the parties deliberately ignore the date, ignore the time. They don't want to mention any time and date. They leave the contract khulla without mentioning anything. So in such cases, the seller is expected to deliver the goods within a reasonable time. What is a reasonable time? It differs from case to case, from contract to contract, from case to case. So therefore, court, after studying the facts and circumstances in each and case, depending on the merits of the case, the court will decide what is reasonable time in that particular case. समझ में आया? What is reasonable time in that particular case? Time is important, place of delivery is important, time is important, date of delivery is important. If there is any specific mention about date, time and place, all those things are to be strictly adhered by the seller. No escape for the seller. He has to deliver the goods according to the date, according to the place, according to the time mentioned in the contract. Anything? अभी ठीक चलता है ना? You go time, place and form. 34. This is 34. This is, if the seller is bound to hand over the documents relating to the goods, he must hand over them at the time and place in the form specified. Different colors for your convenience. I make different colors at the time, place and form. Form is also important. Bill of lading will be in a particular form. Anyway, bill will be in a particular form. Form is also important. Format is also important. Whatever format the buyer requires, the delivery is required. Then in the same format, the seller is expected to deliver the goods. Similarly, and handing over the documents before that time. Sometimes the documents are handed over by the seller in advance, much earlier. What happens then? What is the consequence of it? What is the consequence of it? He has to deliver the goods. He has to deliver the goods by April 31st, April 30th. Then he has delivered the goods by 20th of April, 10 days before, 10 days in advance. What is the consequence of early delivery? There may be some consequence. Consequence is written here. Read it and understand. So early delivery also permitted. It's not prohibited. But some consequence is there. Some consequence is there. What is that consequence? Suppose after delivering the goods, early delivery of the goods, suppose the buyer finds some defect in the goods. So what is that defect is to be brought to the notice of the seller by the buyer. Then buyer may rectify that defect within the stipulated time. The stipulated time is 30th April. He has delivered goods by 20th April. 10 days gap is there. Within 10 days gap, the buyer notices some defect, some deficiency in the goods, and immediately brought it to the notice of the seller that this is the defect the goods are. Then that defect may be rectified, allowed to be rectified by the seller within the stipulated time. What is the stipulated time? Original time is 30th April. Because time is there, stipulated time, still 10 more days are there. Within that stipulated time, seller is free to rectify whatever defect is noticed by the buyer, brought to the notice of the buyer. Contract is